Now, the evidence presented by the party to modify, explain, or add to the terms of written agreement is what we call parol evidence. The provision on the rules of evidence is found in the rules of court, particularly Rule 128 to Rule 133 as amended by AM number 19-08-15-SC. When we say evidence, this is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Yung sinasabi natin na sanctioned by these rules, ayan yung sinasabi natin na rules of court kanina. Take note po na hindi lahat ng circumstances o bagay kung saan makakakuha po tayo ng truth or falsity of a matter alleged ay matatawag po na evidence. Matatawag lang na evidence ang isang bagay or circumstances if it is allowed by the rules of court. Diyan na pumapasok yung katagan natin na evidence must be competent. Dalawang bagay lang ang kailangan para maging admissible ang evidence sa korte. Una, kailangan yung evidence natin is a material or relevant to the issue. Relevant evidence means kailangan yung mga bagay or circumstances na gagamitin natin bilang evidence ay related or connected sa issue. Kailangan yung evidence natin ay may link or relation to the facts in issue. Pangalawa, kailangan yung evidence natin ay competent. Competent evidence means not excluded by the rules of court, by the law, or by the Constitution. So kahit yung isang bagay ay pinapatunayan nito yung truth or falsity ng isang pangyayari, kung hindi ito naaayon sa rules of court, hindi pa rin ito tatanggapin ng korte. Meron po kasi tayong tinatawag na exclusionary rules ng evidence. Exclusionary rules are rules of evidence which excludes any evidence obtained in violation of a person's right or secured through illegal means or sources. So kahit na may malakas tayong ebidensya, kung nakuha po ito unlawfully or illegal ang paraan ng pagkakuha sa ebidensyang ito, hindi pa rin tatanggapin ng korte. At saka, pati na rin po yung mga karagdagang ebidensya na madaderive from that unlawfully obtained evidence ay inadmissible din sa korte. Yan po kasi yung tinatawag natin na fruit of poisonous tree. The fruit of poisonous tree means under exclusionary rules, once the primary source, the tree, is shown to have been unlawfully obtained, any secondary or derivative evidence, which means the fruit derived, is also inadmissible. Now, let's move forward to the different kinds of evidence. We have the first one, that is admissible evidence. Ano po ulit ang admissible evidence? This is an evidence which is relevant to the issue and not excluded by the law or by the rules of court. Huwag po natin kakalimutan yung tatlong requisites ng admissible evidence. Ano po ulit ang mga yon? The evidence must be relevant, material, and competent. When we say irrelevant evidence, this is an evidence which has a relation to the fact in issue as to induce belief in its existence or non-existence. Ang material evidence naman is an evidence directed to prove a fact in issue, while ang competent evidence naman is an evidence which is not excluded by law or by the rules of court. Meron din tayong different classes, types, category, and character of an evidence. We have the first one, the object evidence. This is also called as real evidence, autoptic evidence, or physical evidence. Ang object evidence are those addressed to the senses of court. It is a real thing like knife, blood, and bullet, etc. to prove an issue in the case. And take note that object evidence covers the entire range of human senses, the hearing, sight, smell, taste, and touch. Under the category of object evidence, we have the so-called demonstrative evidence. Demonstrative evidence means that an evidence that merely illustrates a matter of importance in the litigation. It represents or demonstrates the real thing. It is not strictly the real evidence because it is not the very thing involved in the case. An example of this demonstrative evidence would be a map, a diagram, a photograph, and a model. Next is we have documentary evidence. Sa new rules ng evidence po natin, documents as evidence consists of writings, recordings, photographs, or any material containing letter, words, sounds, numbers, figures, symbols, or their equivalent or other modes of written expression offered as proof of their contents. Take note na na-include ang photograph sa definition ng documents. And when we say photograph, it involves still pictures, drawings, stored images, X-ray films, motion pictures, or videos. Now, ang term natin na best evidence rule ay napalitan na din po. Ano po ang pinalit? Yung original document rule. Ano ba ang ibig sabihin ng original document rule? Sabi dito, when the subject of inquiry is the contents of a document, writing, recording, photograph, or other record, no evidence is admissible other than the original document. Now, kapag sinasabi nating original document, an original of a document is the document itself or any counterpart intended to have the same effect by a person executing or issuing it. Pagdating sa photograph naman, an original of the photograph includes the negative or any print therefrom if data is stored in a computer or similar device and a printout or other output readable by sight or other means shown to reflect the data accurately is an original. Sa definition ng original document, nabanggit din ang salitang counterpart. And take note, kapag sinasabi nating counterpart, yan yung duplicate. A duplicate is a counterpart produced by the same impression as the original or from the same matrix or by means of photography including enlargement and miniatures or by mechanical or electronic re-recording or by chemical reproduction or by other equivalent techniques which accurately reproduce the original. Now, admissible ba itong duplicate ng original document sa korte? The answer is yes. A duplicate is admissible to the same extent as the original unless a genuine question is raised as to the authenticity of the original or, in the circumstances, it is unjust or inequitable to admit the duplicate in lieu of the original. Ang original document may be referred as the primary evidence. When we say primary evidence, that which the law regards as affording the greatest certainty of the fact in question. Now, kung meron tayong primary evidence, meron din tayong secondary evidence. Ito po yung copy of the original. Kung wala yung copy of the original, pwede yung recital of the contents of the document in some authentic document. Kung hindi pwede ito, we have the last, which is the testimony of the witness. Ang secondary evidence is also known as the substitutionary evidence, that which is inferior to the primary evidence and is permitted by law only when the best evidence or original document is not available. Kailan po nagiging admissible ang secondary evidence? Meron po tayong 5 circumstances kung saan tinatanggap ang secondary evidence sa korte. Una, nagiging admissible ito kapag napatunayan yung existence or execution ng original document and the cause of its unavailability without bad faith on the part of the offeror. It means the original document may be lost or destroyed or cannot be produced in court. Pangalawa, when the original document is in adverse parties' custody or control, and after such notice to produce it, and after satisfactory proof of its existence, the secondary evidence may be presented. Number 3 is we have the summaries. When the contents of documents, records, photographs, or numerous accounts are voluminous, ibig sabihin, malaki or makapal o sobrang dami yung ating documents at kapag in-examine ng court ito, would result in a great loss of time and the facts sought to be established from them is only the general result of the whole. In that case, the contents of such evidence may be presented in the form of a chart, summary, or calculation. Next is we have public records. There are instances when the original of a document is a public record or is recorded in a public office. In that case, the content of that documents may be proved by a certified copy issued by the public officer in custody thereof. Now, number 5, last but not the least, when the original is not closely related to a controlling issue. Ayon kay Attorney Salvador, when the content of the original document is not the subject of the inquiry of the facts in issue, hindi na natin kailangan na i-present yung original. A photocopy would be enough. Okay, let's move forward to parole evidence rule. Under Rule 130, Section 10, it says here that when the terms of an agreement have been reduced in writing, it is considered that it contained all the terms agreed upon. Ibig sabihin nito, walang ibang ebidensya ang makakapagpatunay sa terms of agreement or napag-usapan kundi ang kasulatan na ginawa. The parole evidence rule forbids any addition to or contradiction of the terms of the written agreement by testimony or other evidence purporting to show that different terms were agreed upon by parties varying the purport of the written contract. Ang ibig sabihin ng parole evidence is something oral or verbal but with reference to contracts. Parole evidence means extraneous evidence or evidence aliende. As used in the rules of court, parole evidence not only refers to oral but also to a written evidence which are outside of or extraneous to the written contract between parties. Sabi natin kanina na kapag ang terms of agreement was reduced into writing, walang ibang ebidensya ang makakapagpatunay sa napag-usapan or napagkasunduan kundi ang writing itself. But take note, this is not absolute because if a party puts in issue in a verified pleading, that party may present evidence to modify, explain, or add to the terms of written agreement. Now, the evidence presented by the party to modify, explain, or add to the terms of written agreement is what we call parole evidence. Ano-ano nga ba yung mga pwedeng maging issue in a verified pleading that makes this parole evidence admissible? Number 1, if there is an intrinsic ambiguity, mistake, or imperfection in the written agreement. Number 2 is the failure of the written agreement to express the true intent and agreement of the parties thereto. Number 3 is the validity of the written agreement. And number 4 is the existence of other terms agreed to by the parties or their successors in interest after the execution of the written agreement. Okay, that is all about the parole evidence rule. And now, let's move to the testimonial evidence. Ang testimonial evidence is a narration or deposition by a person who has observed or has personal knowledge of that which he is testifying. It is that which is submitted to the court through the testimony or deposition of a witness. Ano nga ba ang qualification to become a witness para makapagbigay ng testimonial evidence? Simple lang. When a person can perceive and perceiving can make known their perception to others. Under the category of this testimonial evidence, we have the direct evidence and circumstantial evidence. Ano nga ba ang pinagkaiba nitong dalawa? Kapag sinasabi nating direct evidence, this means evidence which if believed, proves the existence of a fact in issue without inference or presumption. Direct evidence proves a fact without the need to make an inference from another fact. For example, yung testimony ng witness that he personally witnessed the attack by the accused on the victim without the latter's provocation is a direct testimonial evidence. Now, in the absence of a direct evidence, the prosecution may resort to adducing a circumstantial evidence. Ang circumstantial evidence naman is an evidence that indirectly proves a fact in issue through an inference which the fact finder draws from the evidence established. Tinatawag natin ang circumstantial evidence bilang indirect evidence because a fact is being established by making an inference from a previously established or stated fact. For example, yung underwear ni Mr. X na naiwan sa crime scene may be admissible as circumstantial evidence against him, although not sufficient to support a conviction. In criminal cases, meron po kasi tayong tatlong requisites to produce a conviction with a circumstantial evidence. Una, when there is more than one circumstances. Number 2, the facts from which the inferences are derived are proven. And lastly, the combination of all the circumstances is such as to produce conviction beyond reasonable doubt. Take note that circumstantial evidence is not a weaker defense than the direct evidence. In both type of evidence, what is required is proof beyond reasonable doubt. Meron din tayong tinatawag na cumulative evidence at corroborative evidence. Ang cumulative evidence refers to evidence of the same kind and character as that already given and tends to prove the same proposition. For example, when Alpha testifies that he saw Mike shoot Bravo, then Charlie and Delta testifies also na nakita din nila yung sinasabi ni Alpha that Mike shoot Bravo, constitute a cumulative evidence. Sa example natin, meron tayong dalawang ebidensya. Yan yung testimony ni Alpha at yung testimony ni Charlie at Delta. Yan yung sinasabi natin na same kind of evidence. At parehas na pinapatunayan nila that Mike shoot Bravo. Yan naman yung sinasabi natin na same state of facts or same point. Ang corroborative evidence naman is one that is supplementary to the fact already given, tending to strengthen or confirm it. It is an additional evidence of a different character to the same point. For example, if Echo testifies that the gun marked as Exhibit A was the weapon used in shooting to the victim, and the findings of the crime laboratory that the gun bears only the fingerprint of the accused corroborates the testimony of Echo. Dito sa example naman natin ng corroborative evidence, yung sinasabi ni Echo is a testimonial evidence. At yung fingerprint na findings ng crime laboratory ay physical evidence or object evidence. Yan yung sinasabi natin na evidence of different character. Pero parehas or same point lang yung pinapatunayan nila. Now, we have also a positive evidence at negative evidence. Titignan naman natin kung ano ang pinagkaiba nila. Ang positive evidence means when a witness affirms that a certain state of facts does exist or that a certain event happened. Dito, sinasabi ng witness na existing ang isang bagay or nangyari ang isang pangyayari. For example, the testimony of Romeo that he saw Oscar fired a gun to the victim is a positive evidence. Ang negative evidence naman ay kabaliktaran ng positive evidence. It is when a witness states that an event did not occur or that the state of facts alleged to exist does not actually exist. Thus, yung testimony naman ni Romeo that he could not have fired a gun because he was not armed during the incident is a negative evidence. Ang positive evidence may be referred as affirmative evidence while ang negative evidence naman may be referred as denial evidence. But take note, a negative evidence or mere denial by an accused, particularly when not properly corroborated or substantiated by a clear and convincing evidence, cannot prevail over the testimony of a credible witness who testify on affirmative matters. Now, let's move forward. We have also a prima facie evidence and conclusive evidence. When we say prima facie evidence, it is that which is standing alone, unexplained or uncontradicted, is sufficient to maintain the proposition affirmed. For example, in the crime of arson, if the fire is started simultaneously in more than one part of a building, masasabi po natin that the crime of arson has been committed unless it would be rebutted. On the other hand, ang conclusive evidence naman refers to evidence that cannot be contradicted by any other evidence. It is so strong as to overbear any other evidence to the contrary. For example, yung titulo ng lupa na nakapangalan kay Adrian is a conclusive evidence na siya talaga ang may-ari ng lupa.